We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tennessee. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. Boy, I just barely made it with about 2 minutes to spare. I got a phone call before the show from a listener, and I couldn't really get him off the phone, but I so much appreciated the call. He was just telling me that he was so glad that we are doing a community association show. And he's surprised that more law firms don't do a show like this, but there's only one Ask the Experts. We are the biggest, the baddest, the largest. But it was so nice that he was thanking me. He said, I learned so much from your first show. And he is going to start sending in questions. If you've got, we're doing our community association law show with attorney Scott Weiss. They are with the Kamen and Cusimano. Oh, I love that name show. Their firm is one of the greatest not just in Nashville, but in the state of Tennessee. One of the finest community association law firms representing boards of HOA and condo associations. Let's welcome attorney Scott Weiss.
Hey, Steven, how's it going, man?
Hi, Scott.
Your world.
I didn't want to tell you about the phone call I got right before because I was a little late coming on, but it's so nice because you never know who's listening. And to get a phone call like that, just to thank you. And he said, I'm going to start sending, he's actually a board member. He's going to start sending in questions. And he really enjoyed your first show. Last month was Scott's first show. This is the second show. And this category is one of our top categories in Florida. And we're going to make this the best show topic in the state of Tennessee. Scott, tell us about your firm.
So yes, the firm came in Cusimano. We're actually not only in Tennessee, we're in Kentucky, Ohio, and Wisconsin. One thing that's unique about our firm is that the entire law firm, all the attorneys, all the paralegal staff, everyone is dedicated only to the representation of condominiums and homeowner associations. We don't practice any other area of law. So when you hire us for your community association, you're getting our full 100% attention. You don't have other people practicing personal injury or divorce or other areas that could be a distraction. So we're experts in this area of law, and this is all we do. And some people say I'm crazy, but I love it. I just love this area of law. It's great.
Scott, I got to tell you, I've been doing the show now this is going on our 16th year. And I think I told you for 10 years, we've been doing a big law firm in Florida. But this really holds true for any firm. When a firm concentrates in one area, that's the firm you want to hire, you want to retain. I see all the time these firms that have all these shingles, we do bankruptcy law, personal injury law, criminal law. You just concentrate on this one area. And I think that's why you're one of the finest firms. And again, like you said, not only Tennessee, but you're in Kentucky and and you're also in the Milwaukee area. Uh, and what we do here, and we're going to start really setting this up, we're going to answer your questions throughout the show. We've got so many ways that you can ask questions, but the one that everybody seems to want to go to is texting me at 954-336-3767. That's 954-336-3767. And also let us know if you are a HOA or a condo. So we're going to be asking your questions during the show. And if you have a question, just write it on the show. We have a chat box to the right, and we'll be more than happy. So, are you ready to get started, Scott?
I'm ready to let's roll, man. Let's do it.
Okay, so I'm an owner that pays my association dues on time to be allowed to enjoy the amenities in my community. There are owners who always are delinquent, but their friends and neighbors let them into the and gym area only because their access has been blocked. Shouldn't any owner that allows a delinquent owner access to the amenities have the rights denied as well? We hear this all the time, Scott.
Yeah, I mean, the short answer is yeah. In my opinion, I think so. But there's other factors that come into play. First you have to have a way to. First, there needs to be a written policy in place that is adopted by your board of directors. That also is sent to all the owners there, so they are aware of it. So they have notice about it, and it can be sent to everyone. A lot of associations have online portals where they keep documents and things that are pertinent to the subdivision that homeowners can they'll have access to, so they can download copies of these types of policies from that. So the first step is to make sure there's a written policy. Second step is to make sure everyone there has a copy of that policy, so they are aware of what the policy is. And then, yeah, I mean, if that's happening, there needs to be a way to, everything comes down to evidence and proof. So if that's happening, we need to have some, whether there's cameras at the pool, a lot of associations have cameras at the pools, or they have a monitor or whatnot. And so there has to be a way to prove that, yes, these people are doing this. It's not just happening in one incident, but it's on a regular basis. And if that's happening, absolutely, I think there needs to be some repercussions for that.
Scott, what about, can you run for the board if you're delinquent?
That's a great question. I get that a lot. So the short answer is probably yes. That's really dictated by the association's bylaws, which typically talk about the qualifications of someone to serve on a board of directors for their association, and rarely, unfortunately, it's rare that you see something in bylaws that says that if a director is delinquent on assessments, or if they have some other sort of a violation, that they're no longer qualified from the board, or they can be removed from the board by the other directors. It's a very rare thing. I've seen it. I have seen it out there where it does have those provisions, but it's rare. And if the board's considering doing an amendment to the governing documents and want to discuss that, then that would be a perfect time to have that discussion about including some language about directors and their qualifications.
I know we hear on the news, Scott, that there's so many people moving to the Nashville area. We do shows in California, and it's so amazing. There's so many people who are just so frustrated with taxes in California, the way to do business, and there's a lot of people who are moving to the Nashville area. Uh, we just had one of our California longtime listeners who is thinking about moving to Nashville, and he wants to know, do you have to be certified to be on the board in Tennessee?
Another good question. So no, Tennessee does not have a qualification or a requirement that you be certified. I know Florida does, and I'm pretty sure California does, but Tennessee does not have such a requirement.
So how do you teach people? Because there's so much to know about what goes on in an association.
So we do a lot of training for boards. In fact, last night I did a training session here at my office. There's a management company called Century Management, and we had their boards come in and gave them. We talked about amendments last night. How to amend the documents, what's required, how you do it, what are things that need to be amended, what are things that should be amended, and what are things that are okay to amend but not not imperative or mandatory. So education, it really gets down to education, and so again, we do a lot of board training for that purpose, and and to try to make up for the fact we don't have any requirement that they be certified here in Tennessee.
What kind of qualifications, uh, say for background of a person who's thinking about running for the board? Do they need any qualifications at all?
I mean, it's not, not required. I mean, I think it's nice to have it open to anyone who's a homeowner, or unit owner in their association who wants to serve. Oftentimes it's a thankless job. I mean, it's a volunteer job. It's a volunteer. There's a lot to it. There's a lot more to it than oftentimes directors realize that's involved with it. And I mean, of course, sure. Does it help if someone served on a board, for-profit or nonprofit board? Of course, that background certainly is helpful. Business background, accounting background, legal. Of course, those things are helpful because all those issues come into play when you serve on a nonprofit board such as your homeowners association. But is it required? No, it's helpful, but certainly not required. And I encourage anyone who's willing to step up and take the time and volunteer their time to do it. I think it's a great thing, and they should. I would encourage them to do it, regardless of their background.
We just got our first text for the day. This is Marilyn, and she wants to know what do I do to get my community to get more handicap spots?
That's going to probably be more of a local ordinance type thing. I mean, if this happens, I guess they're maybe talking about a condo, maybe with a certain designated
I'm
number
sorry,
of
it was
spots,
a condo.
or maybe they have a swimming pool. So, I mean, the board you could have a vote and determine, whether you want to, allocate more parking spaces to handicap above what the minimum requirement is. I mean, if you're going to do that, I always think it's a good idea to involve the homeowners in those types of decisions. Especially parking is always a problem. Parking is always an issue that comes up frequently. So if you're going to reduce the number of available spaces for anyone and have them exclusively earmarked for handicap above what the minimum requirements are, I think it's a good discussion to have with the homeowners in general and get their thoughts on it as well. Even if the board decides to do it anyway, most owners or unit owners want, it's still a good idea to involve the unit owners, I think, in those discussions.
Here's from a listener. My HOA says the governing documents prohibit owners from parking on the street, but the streets are public. So how can the HOA enforce a no parking restriction on public streets? That's a good question.
It's a great one, and it comes up all the time. This is a great one. And so the reason that if the governing documents prohibit parking on the streets, on the public streets, the reason that is enforceable is because in Tennessee and in pretty much every other state, but definitely in Tennessee, restrictive covenants on real estate, such as homeowner declaration bylaws, the master deed of homeowner associations, those restrictions are interpreted as contracts. And so everyone who becomes an owner of property within the association, when they accept a deed for their property, they agree to be bound by the terms of that contract. Okay. And so because they're bound by the terms of a contract which prohibits street parking, the owners must comply with that contractual obligation. And that's how the association is able to restrict parking on public streets if it's in their governing documents. And that's very important. It must be in their governing documents that way, whether it was originally there or it was done through an amendment. But that's how they're able to do that. Now, the question does come up, well, what about guests and what about tenants and that kind of thing? So, and so that kind of drills down a little bit more on it, and that's a little bit different. Again, it would depend on how the governing documents are worded. If it only includes the owners who are bound by the terms of the restrictive covenants, but some oftentimes will also say that occupants and tenants are also bound by the terms of the restrictive covenants, and even sometimes they'll even extend to guests as well. So if it has that language in there, then it can be enforced against tenants, occupants, and guests as well.
Here in Florida, Scott, we get a lot of calls about service animals. Do you get a lot of calls about service animals?
Not necessarily service, service animals, associations are typically not, or generally speaking, are not governed by the ADA, the American with Disabilities Act, and service animals fall under the ADA. The bigger, what's more frequent in associations is the emotional support animals, the ESAs. And those questions come up quite a bit. When someone has an emotional support animal, they want to, and then the association has a no pet policy, or they charge a fee to people who have pets. And so that question comes up frequently. And the short answer is, if someone has a emotional support animal and they have something that can back that up, that says that they have to have this emotional support animal, then the association, and they can send what's called a request for an accommodation or a modification of the rules for their specific purpose because of that need. And the association, in most cases, is going to need to grant that. Okay, because understand, ESAs, emotional support animals, are not considered pets. They are emotional support animals, which is under the Fair Housing Act, the Federal Fair Housing Act, which is enforced by HUD.
I love this next question. It says, our clubhouse rules state that you cannot hold any political or religious activities, events in the facility. As an owner, I was denied the use of the clubhouse for a wedding because of the board deemed it as a religious activity. Is a wedding considered a religious activity? That's a great question.
It could be, and these are, you got to tread lightly on these things. This type of restriction that could be in the governing documents from this question here. I mentioned the Fair Housing Act, the Federal Fair Housing Act, and there are certain protected classes, and one of those is discrimination for various reasons. One of those reasons is religion, and so there's something called a disparate impact violation, which is basically where you have a document that includes some sort of provision. In this example, it would be the holding religious ceremonies or religious things at the clubhouse, and so religion, that being protected under the Fair Housing Act could be viewed as a disparate impact violation of the Fair Housing Act. It wasn't intentionally included in the governing documents to violate the act, but the fact that it's there could have an impact on a violation of the act, of the Federal Fair Housing Act. And in most states, and Tennessee as well, has its own version of that as well. So you got to tread lightly on these things. And so I would say, in that situation, if that were to happen, if that restriction exists in these homeowners governing documents, and this issue comes up, I would definitely encourage the homeowner to reach out to the board and ask the board to contact the attorneys or the association's attorney for further guidance on that, maybe a legal opinion.
Scott, I'm curious. Give me a few questions that you get most of the time from board members.
So the parking one is always big. I mean, that comes up frequently. Leasing is a big one. We have there might be associations who have your short-term rentals are always controversial in subdivisions, but leasing in general, whether it be short-term or long-term leasing, with the influx of institutional corporate investors buying up properties, and solely for the purpose of leasing them and on a long-term basis, or sometimes even on a short-term basis, that can become problematic, particularly for smaller associations, because if you have investors buying up properties and all they're doing is leasing them, then and there's a cap on leasing, then that cap could be quickly met, or and so the people who want to lease may not be able to lease if that restriction exists in your documents, or if you have one or two owners who own multiple units and own so many of those units that eventually they can actually control everything in the association, just because they can outvote everybody else because they own so many units. So there are a lot of concerns. Also, when it comes to condos, when you have so many units, a certain number of units that are leased, or a percentage of units that are leased versus being owner occupied, that has an impact on conventional loan underwriting guidelines, Fannie Mae, Freddie Mac, and FHA loan underwriting guidelines. And so at some point, if you have too many properties units being leased in a condo, then at least people might have difficulty getting loan financing to purchase or refinance their mortgage if they're already owners.
Well, we're starting to get a lot
So
of texts
that's always a
coming in.
big one.
Yes. We just got a text in. Is it allowed for a board member to also be selling or leasing real estate on the property? Is that a conflict of interest?
Is it a conflict for a board member to sell and lease properties?
I guess to be really also doing real estate, I guess is what they're saying.
It really is, that kind of thing is really fact dependent. So I really need to get a little bit more information about what's going on before I can make a determination as to whether or not there's a conflict of interest or potential conflict.
When you text your question,
sorry, that's a typical lawyer answer. Sorry about that.
Yeah,
sorry about that.
Well,
I'm not trying to avoid it, but I'm just saying there is more information I would need on that. Yeah.
Well, I want people to know that we love answering your questions. We're going to build this up to where we're going to be getting a lot of questions from you, and it's great because it doesn't cost you anything. But we're going to build this. But please give us as much information as you can. Also, tell us if you're an HOA or a condo. Next question is, why am I being sent late notices when my dues are included in my mortgage payments?
That's because your dues are probably not actually included in your mortgage as a part of your escrow payment. Okay, there are very rare situations where that could be a thing, but that's generally speaking, that's not your association dues are not going to be included in your mortgage. The mortgage escrow account will include things like your property taxes and your homeowner's insurance premiums. That'll be part, but like I said, there's only very few and very rare situations where association dues would be included in the escrow payments in your mortgage.
You know, here's a question that we
If you were
get a
told that,
lot.
I get that a lot too. I hear that a lot too. I do hear that a lot.
Yes. We've only got a few more minutes. I want to get in as many questions as I can. This is one that we get a lot, Scott. People wanting to know, why do they have to pay dues when they don't use the pool or the playground or any of the amenities?
Well, it kind of goes back to one of those first questions. When you accept the deed for the property that's made subject to association restrictions and restrictive covenants, then you're a part of the association, whether you use things or not. It's sort of, and I kind of compare this to, because this question does come up sometimes as well. I kind of compare it to, to me. I mean, I pay property taxes on my property every year. Part of my property taxes goes to public schools. Well, I don't have children in public schools, so I don't use the public school system. So it's basically the same thing.
Yes.
But I'm also not entitled to a refund or discount in my property taxes either. And I'm part of the community in which I live. So part of my taxes goes to pay for the public schools, so everyone uses it. So it's kind of the same, works kind of basically the same way, for association dues.
Scott, how do people reach your office? And we just had someone who wrote us wanting to know if you all make presentations, if you come out to the property to make a presentation.
Yeah, sometimes we do that. So they would just need to contact our office and we can talk more about that and how that works, what's all involved to get it arranged and, the ins and outs of that. So yeah, they can just reach out to our office and we can talk to them more about that. We'd love to talk to you about it.
And then how do they reach your office?
So they can, they can certainly call we have our direct number it's area code 615-988-1709. We also have a toll-free number, which is 888-800-1042. And they can reach out to us through our website, which is Tennessee HOA Law.com or Tennessee Condo Law.com. Either one takes you to the same website. And they can email me at sweiss, WEISS, at Kamankus, it's KAMANCUS.com. And they can get all this any one of those ways.
Scott, we are so lucky to have your law firm. Scott will be back again with us next month. Send your questions in. We will try to get to as many of them as we can. We're going to be really building the show up. This is a great opportunity for you to talk to the lawyer. And we're so lucky, we're so blessed we have one of the finest law firms that does community association in the state of Tennessee. Scott, thank you so much. We will see you next month.
Thanks, Stephen, and thanks for everybody for listening. Appreciate everybody's questions. Thanks so much.
Thanks again. And we're going to go to a quick break. When we come back, we have more with Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.